Thank you, Mr. Speaker. I rise today to speak to Bill S-217, an act to amend the criminal code dealing with the detention of accused in custody. It has also become known as Wynn's Law, and I remind this House that this bill was named in honour of Constable David Wynn, who was shot and killed in the line of duty in Alberta. Another senseless loss of a police officer that, in this specific case, was absolutely preventable. I want to thank my honourable colleague from St. Albert, Edmonton for introducing the bill and for what he has contributed to the debate. I personally attended the funeral of Constable Wynn. He died in the line of duty while I was a serving member of the Medicine Police Service. I remember that we in the policing community, along with most of this nation, were shocked and outraged by yet again another failure of our justice system to protect our communities. The amendments proposed in Bill S-217, as passed in the Senate, are intended to mitigate similar situations from happening in the future. The man Constable Wynn was attempting to arrest was out on bail despite having over 30 outstanding charges before the courts and a criminal record, or a lengthy criminal record of over 50 convictions. What is significant in this case, however, is that none of these previous convictions and outstanding charges had been mentioned during his latest bail hearing, allowing him to be released from custody yet again. Bill S-217 amends Section 515 of the Criminal Code to expand the grounds for detention and custody to include the fact that the accused has previously been convicted of criminal offences or is awaiting trial on other charges. It also amends Section 518 of the Criminal Code to require the Crown to lead evidence of the accused's criminal record and outstanding charges at a bail hearing. Currently, across most jurisdictions in Canada, criminal records are routinely introduced at bail hearings. At issue, however, is the fact that the introduction of these records are not mandated or required by law. By simply changing the wording of Section 518 of the Criminal Code from may to shall, Bill S-217 ensures that justices will have the information they need to make an informed decision on bail hearing. During previous debate on Bill S-217 and heard earlier in my previous colleagues' comments, the Liberal government has expressed some concerns. And their view, ensuring that the decision makers in the bail process had relevant information, is not a simple task. They say it's difficult because it requires up-to-date information management systems and fully trained prosecutors, police, and justices. They were concerned that the bill would create policy and legal implications that could result in a bail system that would not function properly for anyone. They also believed that the proposed changes would ultimately impart delay and confusion and would likely have unintended legal and operational consequences for the bail process. In an effort to alleviate and address these concerns, I rely on my 35 years of recent policing experience in order to bring operational life knowledge to this debate. It's important for members of this House and the Canadian public to understand the basics about the release of an accused from custody pending trial, commonly known as bail. The present philosophy of the release provisions of the Criminal Code is that accused persons should not be held in custody except in unusual circumstances. In simple terms, the release pending trial of an accused person is generally affected by two separate and distinct ways. First, and depending on the offence and circumstances, an accused may be released prior to his appearance in court by the police, unless that police officer has yet to establish the identity of that person. They need to secure or preserve evidence or relating to the offence, or they must prevent the continuation or repetition of that offence or commission of another offence, or they believe on reasonable grounds that the person being released from custody will not or fail to attend court. If the officer is content that the above have been satisfied, depending on the seriousness of the offences committed, the officer has various release avenues available to compel the accused attendance in court. On the other hand, there are basically 4 instances where police cannot release an accused, and it would be wrong to suggest they do so using their own release powers. These include where an officer believes it is necessary in the public interest not to release. Secondly, where the accused does not fall into certain categories of offences, such as serious criminal offences, where imprisonment would be punishable by more than 5 years in jail. The other 2 circumstances relate to warrants without release endorsements or warrants of serious offences in other provinces. In these circumstances, an accused may be released as a result of a judicial interim release, having been held by a justice or a judge, as defined in the criminal code. The term judicial interim release simply means that a justice gives judicial consideration based on the facts and law to allowing the right of the accused not to be detained in custody prior to his trial. This is one of the most important areas where a justice must exercise judicial discretion. In all matters involving judicial discretion, a judge is independent of the Crown and the defense. For most accused persons held in custody by the police, this is their first appearance before a justice, and is the key stage in determining their status respecting release or detention. The justice will consider all facts presented by the Crown and the defense and render their decision. During a bail hearing, the justice currently may take into consideration any other charges which the accused is already facing. Some of the considerations which are relevant for a justice in determining the issues of release have to do with, one, the accused's record. The fact that they have a record does not necessarily in itself order a detention. It's only relevant if it relates to the charge before the justice. Other issues include what other charges the accused might be facing. Does he have previous offenses for failing to appear or violating bail release conditions? Is he already detained in custody in respect to any other matter? And what's the gravity and nature and danger of the charges that he's currently facing? There are also two basic grounds for justice to consider for detention. The primary grounds, as we call it, is it necessary to ensure the accused's attendance in court. It's only after the justice rules on those primary grounds that he may go on and consider secondary grounds. And the secondary grounds is it necessary in the public interest or for the protection and safety of the public, which includes the probability that the accused will commit another offense or interfere with the investigation. Now, public interest involves many considerations, not the least of which is the public image of the criminal justice system, the apprehension and conviction of criminals, the attempts at deterrence of crime, and ultimately the protection of Canadians who are socially conscious and law-abiding. This cannot be overemphasized too strongly. Much has been written about the attitudes of citizens concerning accused persons being released and subsequently arrested on allegations committed while they're out and they commit further offenses. It is important to note that as a matter of good practice, the police agency will always provide the justice with all relevant information as indicated above, which should be considered at a bail hearing. In my experience, these records are readily available to police through various national, provincial, and local information management systems. Apparently unknown by the Liberal government, these systems that the justice system and law enforcement agencies rely upon are current and up to date, as lives depend on it. Anything otherwise would be irresponsible. Further, the suggestion that changing the wording as proposed in S-217 is not a simple task, as it would require fully trained prosecutors, police, and justices, diminishes the already proven proficiencies with which these professionals currently perform these tasks now on a daily basis. In closing, Mr. Speaker, I am of the belief that Bill S-217 would strengthen the criminal justice system and protect the lives of law enforcement and Canadians through the requirement of ensuring justices have all relevant accused record information to make an informed decision on public safety. I fully support this excellent bill and encourage all members of this House to do the same. Thank you very much.